Happy Monday. Peace. Happy Monday, everyone. Peace and blessings to you all. It is Empress ShayMarie back for another video, another recording. Hope you guys enjoyed the last few days. And as a very special member of my group and my community always says, have a strong beginning and not a weak end. So I hope you guys had a strong beginning, as always, because nothing is ever ending. It's always beginning. Every day is a new beginning. So I just want to say peace and love to you all. Thank you all for joining me today on this video. I know it isn't live, and as I've started recording, it just helps to me to be more relaxed and help me to take my time with the readings. So I hope you guys have been appreciating the previous reads about this book, which is the Gilberts Law Summaries on Trust. Very, very, very influential book. Very, very, very necessary to read. I've had it in my library for a while and never read it. So I've been hearing it a lot. Study this, read the Gilberts Law. You guys need to listen to this. And it's actually the answer to something that I've been looking for a while. So we're going to pick up today on chapter 3. Chapter 3 is talking about the creation of express trust. Okay. So in this chapter, we're going to go over again the methods of trust creation of the inter vivos trust. This is really going to be up my alley. Creation of testamentary trust and revocable inter vivos trust as will substitutes, special problems. Okay. So with that being said, I'm going to go ahead and get started. And key exam issues. Exam questions often require you to consider whether a trust has in fact been created. Trust may be created during the settler's lifetime or by will. In either case, be sure to watch for the possible failure of the trust to meet formal requirements in expressing essential trust elements. Number 1, inter vivos trust. For example, involving the creation of inter vivos trust. A. Consider whether there was an effective present transfer of property to the trustee, such as watch for delivery issues, or an effective present declaration of trust. B. Remember that consideration is required only if an enforceable contract to create a trust must be found because the necessary present transfer of declaration is lacking. I'm going to repeat that again. B, remember that consideration is required only if an enforceable contract to create a trust must be found because the necessary present transfer or declaration is lacking. C, consider whether the intended trust, especially for real property, must be and is expressed or declared in writing. If so, analyze carefully and in specific terms whether the facts and circumstances provide grounds upon which any violation of a statute of frauds requirement can be overcome via a constructive trust, and if this would matter under the facts, whether the remedy would accomplish the intended purpose or merely restore the property to the transferor. D. Regardless of the statute of frauds, if there is a writing, consider possible peril evidence issues. E. Consider whether a possible trust is illusory or a mere agency, or will otherwise fail as an inter vivos trust because it is deemed testamentary, while also failing to comply with the requirements for the execution of wills. In bank account cases, be alert to the recognition, applicability, and consequences of the totem trust doctrine. If the rights of a spouse or creditor are involved, such a claimant is, of course, aided by a trust failure on the above grounds, but also consider whether any statute or decision in the state gives the claimant special protection even if the trust is otherwise valid. Number two, testamentary trust. For exam questions involving creation of trust by will, A, make sure that the essential elements of a trust, res, beneficiary, and purpose, are ascertainable from the will or established in some other manner that meets the requirements of the applicable Wills Act. B, the carrying out of an oral or implied promise is otherwise objectionable under the Wills Act. Consider whether, under the circumstances, a constructive trust remedy is available for the enforcement of that promise, and watch for distinctions between secret and semi-secret situations. In pour-over cases, if the question does not involve statutory authorization, consider the quite different doctrines of incorporation by reference, which tends to be rigid, and independent significance, potentially more flexible, and their possible applicability to the particular facts of the case. A. Methods of trust creation. Number one, in general, Section 258. The principal methods of creating a trust are by declaration of trust, transfer in trust, exercise of the power of appointment, and contract. Number two, declaration, Section 259. A trust may be created by a declaration by the owner of the property that she holds in trust for another. Russell versus Russell. Massachusetts 1984. Number three, transfer, Section 260. A trust may also be created by a transfer of property by the owner or owners to another or others as trustees for the benefit of the transferors or third persons or both. A, testamentary, Section 261. If the transfer is made by a decedent's will, the trust is a testamentary trust. Inter vivos, B, Section 262. If the transfer is made or contracted for by the owner during her lifetime, the trust is an inter vivos or living trust. Such trust may be revocable and amendable in whole or in part, or two, irrevocable, including where the settlor retains a limited power to amend. Number four, appointment, Section 263. A trust may be created by the exercise of a power of appointment. Example, testator divides property to daughter for life with the, quote, power to appoint the remainder among the children of sons, end quote. Daughter then makes an appointment to trustee and trust for sons' children until the youngest is 21 years old, and then to sons' children in equal shares. This is a valid trust. Contract, number five, Section 264. A valid inter vivos trust may be based on a promise enforceable under the law of contracts to create a trust for valuable consideration. A promises that A will hold certain property in trust for B's children, or as in Section 408 infra, where there is an insurance trust. It is not conceptually clear whether such a trust is created presently by the contract with the promise, a choice in action as the res, or whether it is to be created later by the transfer by A or by the insurance company that could be compelled by court as a gratuitous promise could not. Also, this type of case is to be distinguished from a present assignment of another's enforceable promise, which does immediately create a trust of a choice in action. One form of insurance trust is created in this manner by transfer of the policy to the trustee. See Infra Section 408. B, creation of inter vivos trust. Number 1, requirement of effective present transfer or declaration. Section 265. To create a living or inter vivos trust, there must be an effective present transfer of trust res. A conceptual problem exists regarding a declaration of trust. The present declaration may be said to substitute for a transfer, but it could also be said that there is a transfer from the settlor as an individual to the settlor as trustee. The latter approach is followed here, but the question is essentially semantic and moot. Also, see generally the closely related discussion of present intention to create a trust, supra section 81 through 91. The sufficiency of a transfer is determined by the standards applicable to similar non-trust transfers under real property and personal property law, mostly doctrine involving gift transfers. Restatement 3D, section 10 and 16. A, present versus future transfer, section 266. Because there must be an immediate present transfer of the trust res to the trustee, a mere promise or expression of intent to hold or transfer property in trust in the future does not create a trust, at least in the absence of consideration. See infra, section 293. Example. Settler writes, quote, I hereby promise to hold Black Acre in trust for cousin, end quote. The normal interpretation of such language does not indicate an immediate present transfer. Although a contrary meaning might be shown, it appears to be simply a promise to hold in trust sometime in the future with no trust created. Compare, but if settler writes, quote, I hereby declare myself trustee of Blackacre for a cousin, this language establishes a present transfer and a valid trust is created. B, delivery to trustee, section 267. A transfer requires adequate delivery of the trust res to the trustee, although this can be accomplished by proper delivery in escrow or to the trustee's agent. Also, the owner of the res must intend to transfer the property to the transferee as trustee, not merely as agent for the owner. And that comes from State X Rel Teague versus Home Indemnity Company, supersection 41. Example, the would-be settler's execution and delivery of a mere power of attorney, a written agency by which title to the trust res could be transferred by the agent is not considered the equivalent of delivery of the res itself because the power could be revoked before title is vested in the trustee. The owner's agent is but an extension of the owner. Farmers Loan and Trust Company versus Winthrop, 1924. Number 1, personal property. Section 268. If chattels are involved, delivery means the physical handling over or handing over of possession of the chattel or of a deed, a writing stating the gift to the trustee. If the nature of the property is such that it cannot readily and readily be physically transferred, such as patent rights or bank accounts, symbolic or constructive delivery is sufficient. Thus, a deed or of gift or a bank passbook or other document is usually delivered to the trustee. Number 2, real property, section 269. If real property is involved, the settler must have made an effective conveyance of title to the land involved, usually by delivering an appropriate deed, but see infra section 271. See restatement 3D section 16 CMT B as to what constitutes an adequate delivery of a deed to real property. See property summary. 3. Settler as trustee. A. Segregation, section 270. Where the settler declares himself trustee, the requirement of delivery is satisfied by the act of segregating the trust assets from his other property with the necessary trust intent, or the deed may take the form of a property declaration in writing, identifying the rest, etc. B. Real property, Section 271. Where real property is involved, the settlers, trustees, execution of a writing declaring the trust is generally deemed legally sufficient. Estate of Hegstad, 1993. Restatement 3D, Section 10 CMTE. Further acts, such as acknowledgement and recording, are not required except by a few statutes. Even when a standard deed form is used, but are desirable both to protect beneficiaries from third parties and to evidence the settler's intent that a trust arise immediately with respect to the property. Number 4, effect of no trustee, Section 272. As pointed out previously, Section 135, the existence of a competent trustee is not necessarily essential to the creation of a trust. If a will fails to name a trustee, or if the named trustee is dead or incompetent or refuses to serve, and the instrument does not name a substitute or successor, the appropriate court will appoint a substitute, provided the transfer has been effective. Maxim, equity will not allow a trust to fail for want of trustee. A. Constructive trustee, Section 273. In an inter vivos trust, however, the absence of a trustee will raise a problem of delivery and hence of transfer. See Section 137. There is no transfer if the settler has not delivered the property to someone as trustee. But even in such a case, if the requirement of an effective conveyance and trust are otherwise present, and the only deficiency is that no trustee was named, or the named trustee is disqualified or dead, an enforceable trust may result. Title may be deemed held in the settler as constructive trustee or in the intended agent of the intended trustee, to be transferred to whomever the court appoints as trustee. See Section 135. Dominy versus Stanley, 1926, Georgia, and see Whitmire versus Heligenstein, Section 139. Exam tip. If you encounter an exam question in which the settler of an intended inter vivos trust fails to name the trustee, or the named trustee dies or refuses to serve, you should first state the rule that a trust generally will not fail for lack of trustee. Then you should address the delivery problem. If there is no trustee, there is no one to whom delivery can be made. Without delivery, there is no transfer and thus no trust. But your analysis does not end there. If all the other requirements of a valid inter vivos trust are met, such as intent, res, definite beneficiaries, valid trust purpose, you should note that the court may deem the settler constructive trustee of the property, with the duty to transfer the property to a trustee appointed by the court. See notice to an acceptance by trustee, Section 274. If an effective transfer has been made, a valid trust exists even if the trustee has not been made aware of it. Neither notice nor acceptance by the trustee is essential to formation of the trust. Restatement 3D, Section 14. Number 1, trustee unaware, Section 275. In many valid testamentary trusts, the trustee is unaware of the trust until the descendant dies. Of course, in most cases of living trust, the requirement of delivery above assures that the trustee is made aware of the trust. Nevertheless, where this does not happen, a trust may be created without the knowledge of the trustee, and where there has been constructive delivery of the trust res or delivery to a third party, such as an escrow, the fact that the settler did not notify the trustee may, However, as an evidentiary matter, reflect on whether the settler had the requisite intent presently to create an inter vivos trust. If a question is raised on that issue, see Supra Section 84. Alternatively, the court may conclude that a revocable trust was intended or that the failure to inform the intended trustee had no significance and that an irrevocable trust was created. Acceptance presumed. Number 2, Section 267 or 276. The trustee's acceptance is presumed unless the contrary is shown. The trust cannot be forced upon him. However, he is free to disclaim the trusteeship anytime prior to accepting it. Restatement 3D, Section 35. A. Disclaimer, Section 277. If there has been an effective transfer, but the trustee disclaims before acceptance, the trust does not fail for lack of a trustee. Rather, unless a court holds that technical title vests in the trustee, the result may be that title remains in the settler, subject to the trust until a substitute trustee is appointed. See above. Few actual cases have faced a controversy over the matter. Okay, so let's read these side notes. It says, have you disclaimed the presumed and unrebutted trusteeship for an all cap name registered by the state? It's the state's name because they registered it, and the state appears at the top, not your private family estate name granted to without the state. Okay, let's keep reading. There was a star by that. Okay, so retraction, Section 278. Once having disclaimed, the trustee is usually not permitted to retract the disclaimer, although courts may permit a retraction where no harm or prejudice will result. Carter versus Carter, Section 1936. I believe that's Pennsylvania. I wonder if this is part of my heritage because my grandfather's surname is Carter on my mother's side. So, number 3, trustee's obligation. Section 279. Once having accepted the trust, the trustee is bound by all of the fiduciary obligations imposed by law and by the terms of the trust, and can be held personally liable for neglect. See infra section 611 through 620. Resignation alone does not relieve the trustee of these duties and responsibilities. Ordinarily, the trustee must petition the court for a replacement, even if the trust instrument expressly authorizes resignation. The duties of one who has accepted the trust continue until a successor is in place. Restatement 3D, Section 36. Number 4, acceptance relates back. Section 280. The trustee's acceptance normally relates back to the time the trust came into being. Thus, acceptance by a testamentary trustee is effective from the date of the settler's death. A. Duties prior to acceptance, Section 281. Although for many purposes, accrual of beneficiaries' rights to benefit. Although for many purposes, such as accrual of beneficiaries' rights to benefits, a trust becomes effective at the time it comes into existence. The trustee normally has the fiduciary duties until acceptance of the trusteeship expressly or impliedly occurs. D. Notice to and acceptance by the beneficiary, Section 282. Notice to the beneficiary that the settler intends to create a trust or has created one is not necessary for a valid trust. Acceptance by the beneficiary also is not essential to trust formation. Number 1, evidentiary effect of lack of notice. Section 283. Again, however, if the question arises, the fact that the settlor has not notified the beneficiary may, as an evidentiary matter, reflect on whether the settlor actually had the requisite intent presently to create a trust or was merely contemplating a future trust. Number two, acceptance presumed. Section 284. Although the beneficiary's acceptance is not required to create the trust, acceptance by a beneficiary is normally presumed and will be implied from his voluntary retention of any trust distribution with knowledge or with the knowledge of the trust terms. Upon acceptance, the beneficiary's rights are normally retroactive to the date the trust was created. A disclaimer, section 285. A trust cannot be forced upon a beneficiary. Thus, a person named as beneficiary has the right within a reasonable time after learning of the trust to disclaim or renounce the beneficial interest absent some of expressed or implied acceptance. Upon disclaimer, depending on construction of the other trust provisions, other beneficial interests are adapted, such as a remainder interest following. A renounced life interest may accelerate to carry out the trust as nearly as possible to achieve the settlor's purpose. If no filing in is appropriate, the trustee holds the disclaimed interest upon resulting trust for the settlor. Libby versus Frost, 1903. I believe that's in Maine. 1. Note, the requirements for a qualified disclaimer for tax purposes may be quite different from the statutory or common law of a given state. CIRC, Internal Revenue Code, Section 2518. B. Partial acceptance, Section 286. It is sometimes said that a beneficiary's acceptance or disclaimer must be of the whole of his rights under the trust, i.e., the beneficiary cannot accept or reject in part. But this is not so, unless, as is clearly the case, the different interests of a beneficiary are inseparable or interdependent. A situation likely to exist only where both benefits and burdens are involved, in which case it would be inequitable and thus impermissible to accept only the former. C. Acceptance or disclaimer relates back to Section 287. Once an acceptance or disclaimer is made, it is generally said that the beneficiary's actions is final and that it relates back to the date of trust creation. Storer versus Miller, 2D Circuit 1923, circa 1923. D, assignment of interest, Section 288. Despite an acceptance, of course, a beneficiary generally need not retain the beneficial interest because, unless inalienable, the interest can be assigned or released. A defective attempt to disclaim may thus be treated as a release, which may have different effects for tax or creditor purposes, such as a release may be a fraudulent conveyance where a disclaimer would not. E. Retraction, Section 289. A beneficiary may even be allowed to withdraw a renunciation where there has been no change of position by others that would render the result inequitable. In Ray Cranston's Will Trust, 1949, Chapter 523. Exam tip. Remember that although notice to and acceptance by the trustee and beneficiaries are not essential to the validity of the trust, the failure to give such notice may serve as evidence contesting an alleged present intention to create a trust. Number 2, registration of trust, Uniform Probate Code, Section 290. In states that have adopted and retained the Uniform Probate Code, UPC, as promulgated in 1969, the trustee of either the inter vivos or testamentary trust is directed to register the same with the probate court at the principal place of administration of the trust, UPC 7101, to 102. The registration must identify the trustee, the settlor, and the date of the trust instrument. I'm going to read this again. Registration of trust. Uniform Probate Code, Section 290. In states that have adopted and retained the Uniform Probate Code, UPC, so you need to see if your state has adopted this code, as promulgated in 1969, the trustee of either an inter vivos trust or a testamentary trust is directed to register the same with the probate court at the principal place of administration of the trust. UPC section 7-102 through 101 through 102. The registration must identify the trustees, the settlor, and the date of the trust instrument. A. Effects of failure to register. Section 291. Failure to register the trust does not affect its validity, but subjects the trustee to possible removal, denial of compensation or surcharge by the court. Also, trust provisions purporting to excuse the trustee from registering are ineffective. UPC section 17-104. B. Distinguish other states. Section 292. Non-UPC jurisdictions do not require registration of trust. In these states, there is no attendant public disclosure to inhibit the creation of living trusts, but testamentary trusts are subject to the usual publicity of probate procedures and, in some states, to continuing jurisdiction of the probate court. 3. Role of consideration, Section 293. Consideration is not essential to the creation of a trust. Indeed, most trusts are gratuitous. Leeper versus Taylor, Missouri, 1892, Restatement 3D, Section 15. Nonetheless, the presence or absence of consideration may be important whether an attempted trust would otherwise fail for lack of present transfer. A. Promise to create future trust, Section 294. An unenforceable promise to hold or transfer property in trust in the future does not create a trust. See Supra, Section 84. Gratuitous promise, Section 295. If the promise is given gratuitously, normally it cannot be enforced, even if made in writing. The promise is not enforceable in equity, and damages will not be awarded for its breach, absent elements of promissory estoppel. See contracts summaries, Austin versus Young, New Jersey, 1919. Number 2, with consideration, Section 296. If consideration was given for the promise, however, it may be enforceable as a contract. Enforcement may be at law, and because trust obligations are unique, enforcement in equity is available, including by the general view via specific performance. Daniel versus Snowden Association, Mississippi, 1987. When a trust arises, A, Section 297. When an enforceable promise is made to create a trust sometime in the future, including one arising from a beneficiary designation, such as under an insurance policy, a problem arises in determining at what point in time the trust actually arises. One view is that a trust arises at the time consideration is given, and the trust res is a choice in action as enforceable promise. This was the preferred interpretation of the second restatement of trust, which opened that when such a trust arises in a matter of when the settlor intended fiduciary duties to arise. Restatement 2D, Section 25 and 30. The other view preferred by the third restatement is that while there is an enforceable promise to make a conveyance at some later time, no trust arises until the conveyance is made, absent a manifestation of contrary intent. Restatement 3D, Section 10 CMTG. The question of when a trust arises may affect not only the point may not The question of when a trust arises may affect not only the point at which the trustee's fiduciary duties commence, but also when the perpetuities period begins to run. Example, husband promises wife in writing that if she marries him, he will convey Blackacre in trust for wife's mother. Wife marries husband, regardless of whether conceptually the trust arises at the marriage date or when husband makes the conveyance. His promise is enforceable in equity or at law. Ineffective trust transfer, Section 298. Where consideration has been received by the settlor, a trust may be enforced even though the requisite transfer is somewhat defective. This is based on the equitable principle that at least in litigation between the parties, equity is inclined to, quote, treat as done that which ought to have been done. Do unto others as you would want others to do it to you, to protect the interests of a beneficiary who paid for the trust. Example, sister pays a large sum of money to brother in consideration for which brother agrees to transfer Blackacre to himself as trustee for sister and her family. Brother's deed, however, is imperfectly executed and under the applicable law is not effective to transfer title. In litigation between sister and brother, specific performance would be ordered, or a constructive trust in sister's favor would be declared. But sister's equity, her right to enforce the promised trust, would be cut off if brother had in the meantime transferred title to an innocent purchaser. C. Promises regarding after acquired property, Section 299. A purported declaration or transfer in trust of property that the settlor does not presently own fails for lack of a present transfer, there being no property to transfer and to become a trust res. Example. Daughter transfers to friend in trust, quote, the property I expect to receive as heir of my father's estate, end quote. If daughter's father had died before the assignment, the trust is good, assuming daughter's father was still alive, however, so that only an expectancy is involved. The question of whether there is a trust of the designated property when it is later acquired depends on whether consideration was given for the promise. Number one, gratuitous. 3. If the promise was gratuitous, no trust arises unless the settlor, daughter in the above example, manifest her intentions to create a trust with respect to the property after its acquisition, in which the trust becomes effective at that time. See supersection 85. Number 2, consideration present, section 301. If, however, the settler received consideration, her promise is specifically enforceable and the trust thus arises immediately, or at least may be specifically enforced upon her acquisition of the property, even without later expression of trust intent. Restatement 2D, section 86. Exam tip. Remember the difference between expectancies and future interests. A mere expectancy, i.e., not yet in legal existence, does not constitute sufficient trust res, but a future interest, so i.e., a presently existing legally protected right and property, although possession may be postponed until the future date, does. However, if the settler's promise to hold an expectancy and trust is supported by a consideration, a valid trust arises when the settler acquires the property. Number 4, requirement of a writing. Statute of Frauds, Section 302. Oral trusts of personal property are valid at common law, but in a few states this has been changed by statute, although legislation requiring a writing for a declaration of trust is somewhat more common. On the other hand, trust of land must be evidenced by some writing signed by a party empowered at the time to impress the trust upon uh, title property. Okay. Approach to enforceability of trust, statute of frauds. Okay, this diagram says, is the trust res real or personal property? If it is real property, the question asks, is there a writing signed by the party with the power to create a trust? If the question is no, it says, was there sufficient part performance, usually possession plus some other act? If the question is no, it says, is the trustee willing to perform trust? If the question is no, it says, unforceable trust, but consider equitable remedies, constructive trust, especially in fraud, mistakes, if especially in fraud, mistake, duress, undue influence. Okay, so let's go back up. If the question is yes, in regards to is the trust real property, real or personal property, on the real property side, if the answer is yes, then um, it says, is there a writing signed by the property? The answer is yes. It says it is an enforceable trust as long as other trust elements are met. And then, okay, so all these lead back to here. Was there sufficient part? So if the answer is yes, it's enforceable. Is the trustee willing to perform trust? Yes. Is the trustee willing to perform trust? If the answer is yes, unenforceable trust but may be performed as long as trustee is willing. Okay. All right. So I guess over here this is personal property. So if it's personal property, if the trust reads as personal property, it says it is an enforceable trust. Okay. All right. All of this leads to this, back to the same question. If it's personal property, if it's personal property, it really doesn't get down here. Okay, is what I'm looking at. You guys comment in the section. Let me know what you think about that diaphragm. Okay. Wow, I was muted. Section F, Uniform Testamentary Additions to Trust Acts. Section 394. The validity of pour-over provisions is now clearly established in most states by pour-over trust legislation based on the Uniform Testamentary Additions to Trust Acts. Basically, the act validates a testamentary gift to any pre-existing trust evidenced by a writing, provided the trust is sufficiently described in the testator's will. 1. A testator or third party's trust. Section 395. The pour-over may be to a pre-existing trust created by the testator or by a third person, and the trust may be modifiable or, in fact, modified even after the testator's death. B. See Supra Section 393, Exam 2. If you see a pour-over gift on your exam, keep in mind that the doctrines of incorporation by reference and facts of independent significance have been used to uphold pour-overs, but also note that most states have enacted the Uniform Testamentary Additions to Trust Act or even legislation, which validates a testamentary gift to an inter vivos trust created by the testator or another person, even if the trust is revocable or amendable, and even if the trust is amended after the will's execution. Number 2, unfunded trust, Section 396. The size, character, and evidence and even existence of the trust corpus during the testator's lifetime is immaterial. Thus, testators often create living trusts with no assets and by subsequent written trust amendments without testamentary formalities alter the disposition of the assets passing under the wills. 3. Life Insurance Trust, Section 397. The Act specifically validates gifts to either funded or unfunded life insurance trust. See Infra Section 412, even where the testator has reserved all rights of ownership in the policies. 4. Inter vivos Trust, Section 398. Finally, the Act provides that the property bequeathed or devised to a pre-existing trust becomes a part of the inter vivos trust and is not held in a separate testamentary trust. D. Revocable inter vivos trust as will substitutes. Special problems. Is a revocable trust testamentary? Section 399. The special problem posed by the creation of revocable trust is their effectiveness as valid, sustainable inter vivos trust, as a disposition of the property and a creation of beneficial interest during life. If the trust fails, if it is deemed illusory or a mere agency, envisaging the trustee as the agent of the settlor, then there is no effective transfer and no present trust. The trust having failed, the properties remain properties of the would-be settler and thus become assets of her probate estate. To control the devolution of estate assets rather than have them pass intestate, there must be a valid will. The issue becomes whether the trust document could then serve as such a valid will. The issue becomes whether the trust document could then serve as a valid testamentary instrument. Certainly not unless it is executed with testamentary formalities such as subscription by witnesses. Even then, there would be a problem of whether testamentary intent existed when the document was executed as a trust. And in many states, there is a requirement of publication, which requires a testator to declare that the instrument in question is her will. This whole array of issues is sometimes discussed in cases as a question of whether an operative effect or purported living trust is really testamentary and thus ineffective, or what of the formalities and other requirements prescribed by the Wills Act. A. Passing of interest, Section 400. Cases have stated that this depends on whether any interest really passes to the beneficiaries during the would-be settler's lifetime or whether the transfer is merely one to take effect at or after the transferor's death. Unfortunately, this merely begs or restates the question. So also do statements that the result depends on whether an interest presently vests in beneficiaries other than the settler, i.e., whether an interest is presently created in transferees or whether no such interest vests, i.e., passes until the settler's death. Exam tip. If you encounter an exam question that requires you to determine whether a purported revocable trust is really testamentary and possibly ineffective if it was not executed with testamentary formalities, see will summary. It is important to remember that a will is not effective until the testator's death. Thus, whether an interest vests before or after the settler's death is not determinative in analyzing the validity of a revocable trust. Under the modern view, it is if the transfer presently creates some interest, even if contingent or revocable, it is not testamentary. Okay. B. Retained powers, not a bar. Section 401. If, however, a trust is presently created and interests are presently created in beneficiaries, the mere fact that the settler has retained benefits such as a right to the income for life or has retained power subsequently to amend or revoke the trust or a combination of these does not prevent the trust from being a valid presently existing trust with presently existing interests and other beneficiaries. Although important, this statement too merely states a conclusion that follows from having decided on some other basis that the purported trust was real and effective, but it does not tell us objectively why a purported trust is or is not recognized. Intent, Section 402. C. Another way courts have expressed their approach to resolving the question is the attempt to ascertain the real intention of the would-be transferor. Did the settler intend to create a trust now, i.e., intend something more than an agency? Did the grantor intend something that was to be taken seriously as a present disposition of property, even though some of the interests created in that disposition were beneficial interests or powers, even to revoke and amend retained by the grantor? Number one, application. By focusing on intention, of course, by focusing on intention, courts may better come to concentrate on objective facts. Was the procedure in creating the trust and the expression of the trust terms to the kind of thing to be expected of a settler who took these actions seriously, such as were the expressions casual conversations or a carefully worded writing? Were they the type of things that would be done by one who expected others to take the action and statements seriously? It is fairly clear that the would-be settler understood the significance of what was taking place. Essentially, does a court get the sense of security that it gets from a will? And did the alleged settler subsequently act in a way that suggested that he took the trust seriously? Or did she simply treat the trustee as she might an agent? Inasmuch as there is nothing inherently fatal in the retention of powers to amend or revoke or to direct the trustee, it is not conclusive that the settler changed the trust terms or exercised some control, but the pattern of behavior in this respect, such as the frequency and casualness of such intrusions, are relevant. Modern authority, Section 403. The important point to keep in mind is that At least under modern cases in virtually all states, a settler can validly create an effective, non testamentary trust during life, despite the fact that the settler retains interest and extensive powers, including to revoke and amend. According to such modern case law and the better view, the settler can even and often does serve as trustee or co trustee or hold administrative powers under such a trust. The real question, therefore, is did the purported settler in fact create a trust? Was the requisite intent present? Most of the trusts that have failed in modern cases involved oral and casual acts of alleged trust creation. The recognition of a valid present trust is not precluded by the mere fact that remainder beneficiaries, often the only beneficiaries other than the settler, who usually has the exclusive right to income payments during life, are a class that is not ascertainable at the time the trust is created, such as my issue living at my death, or my heirs at law, or even persons to be designated by the testator in the exercise of a power of appointment, in default of which the remainder goes to the settler's descendants, or the like. Restatement 3D, Section 25, 1. 1. Res requirement, Section 404. There must, however, be a specific trust res, for no trust can exist without trust property. Thus, a trust of properties to be subsequently designated or to be received under my will would not suffice to create a living trust because of the absence of presently existing and presently identifiable trust property. On the other hand, as long as there is present trust corpus, there is nothing wrong with the fact that other properties may be added subsequently during life or by will, such as testamentary additions, by pouring over supra. Thus, obviously, if anything interferes with the essentials of a present res and a present transfer, the question of whether the trust is testamentary is not reached. Two, beneficiaries other than settler, Section 405. Also, on its face, the trust must create some interest in some category of beneficiaries other than the settler, but those can be purely future interests, and they can, at least according to proper analysis, be created in ascertained and unascertained and even unborn purposes. Also, the interest can be vested or contingent, despite careless language in many cases misusing the term vested. Such interest can even be subject to change or selection or appointment by the settler, and it should not be factual that such a designation may come from the settler's will, for there is no theoretical obstacle to the settler's retention of a testamentary power of appointment. Number 3, subjective test, Section 406. Thus, unless the required res or transfer is lacking, the question of whether a supposed inter vivos trust is testamentary in nature and thus fails as a living trust does not turn on readily recognizable objective criteria. Cases turn on the aggregate of the types of factors mentioned previously and on the general sense one gets of the situation. The coincidence our court the confidence a court can have that the creation of the purported trust was misunderstood and taken seriously by the settler, and that the proof of the trust is reasonably reliable and satisfactorily indicative of a true trust intention. A special type of revocable trust. Life insurance trust. Irrevocable life insurance trust, Section 407. Normally, an irrevocable life insurance trust is created simply by the transfer, i.e., assignment of one or more life insurance policies to a trustee, much as any other item of property might be transferred to a trustee who thereby becomes its legal owner. In such a case, the life insurance policy itself becomes the trust res. Even though the trustee has little in the way of active duties until the insured dies and the proceeds are located, the trust is not a passive one and its validity has not been a source of either practical or theoretical difficulty. Revocable life insurance trust, Section 408. Serious conceptual and practical problems arise, however, with revocable life insurance trusts for a variety of reasons. Nevertheless, case law has also consistently upheld these trusts despite allegations that they are defectively testamentary in character or simply too insubstantial to constitute present trust. Gurnett versus Mutual Life Insurance Company, 191, 1934, and Gordon versus Portland Trust Bank, 1954 in Oregon. Unless there was some peculiar defect in the attempted creation of the trust, Frost versus Frost, Super Section 138, purported transfer of policies was incomplete. There being no delivery for one of a presently identified trustee. A basis of challenge, Section 409. Challenges to the validity of a revocable life insurance trust are generally based on the following arguments. 1. Testamentary character, Section 410. One argument raised against such trust is that the trust is testamentary in character and too illusory and insubstantial to be upheld as a present trust. See Supra Section 399. In addition to the factors previously discussed, the trust is subject to the further objection that it is essentially inactive until the testator's death and is similar in operation and effect to a will. Number 2, lack of res until settler's death. Section 411. An additional basis for challenge exists too, in that it is also urged that the trust lacks a res until the time of the settler's insured death. Understanding courts' responses to this argument requires a description of the ways in which insurance trusts are created. Example 2. Be sure to remember that although a trust generally cannot exist without trust property, see Super Section 92 Exec, life insurance trusts have been held despite the absence of a significant res prior to the settler's death. B. Creation of revocable life insurance trust, Section 412. Revocable life insurance trusts are generally created in either of two ways. 1. The owner of the life insurance policy make a designation of the trustee as the payee of the policy proceeds, normally designating the payee as trustee of the trust, and the settler of the trustee usually execute a written trust agreement. In nearly all states, however, an oral promise by the payee to hold in trust for other oral manifestations of the trust terms will be effective if satisfactorily proven. The trustee may be given custody of the policy for convenience, but it is not assigned, and the policy ownership remains in the settler's insured. Number 2, a less frequently employed method is to assign the insurance policies themselves to the trustee pursuant to a trust agreement. Whichever of these methods is used, the trust may be either funded where there is a transfer to the trustee of the property, the income of which may be issued to pay premiums, or unfunded with no other assets placed in the trust. C. Based upon which revocable insurance trusts are upheld, Section 413. In the absence of special circumstances creating defects, such as a lack of a trustee and thus lack of delivery, or the absence of properly ascertainable beneficiaries, revocable life insurance trusts have inevitably been sustained in one way or another by the courts. Testamentary character, Section 414. The trusts are no more testamentary or tentative in character than any other revocable or amendable trust. Number two, res 415. Despite the argument that the trust has no res until the insured's death, the courts have upheld such trust on the basis of one's two theories. A. Choice in action is res. The trust may be upheld under the rationale that the trustee's rights as the revocably designated beneficiary of the policy itself constitutes a property interest, not a bare expectancy, but a choice in action in the form of a third-party beneficiary, right under the contract, an interest that has been called vested subject to devicement, which serves as the trust property. B. Proceeds paid at death are res. Section 417. Under the more modern rationale, the trust is created at the insured's death by operation of contract, really by a pair of contracts, one between the insurance company and the settler, and the other between the settler and the trustee. In other words, the insurance policy contractually requires the insurance company to make a transfer of the trustee to the trustee, and the transfer creates a trust that the trustee must carry out in accordance with the terms of the trust agreement. Under this view, the proceeds are readily recognizable as the res. According to this analyst, a trust is created at the insured's death by a present transfer that is no more invalid as a testamentary disposition than any other payment of insurance proceeds at an insured's death, where no trust is involved. As in other trust contract cases, the intention of the settler and the awareness of, i.e., fairness to the trustee, should control on the question of when the trust arises. See Supra, Section 297. B. Totem Trust. So-called tentative or savings deposit trust. Section 418. Deposits are often made rather casually with banks or savings and loan associations in the name of the depositor in trust for another person. Is this really intended to be a trust? If so, should it nevertheless fail as an attempted testamentary disposition? If it is a valid trust, what are its terms? Who has rights and when do they attach? Example, depositor deposits funds in bank in her own name, quote, as trustee for child, end quote, or in the name of depositor, or in the name of, quote, depositor in trust for child. This is the classic totem trust situation. Compare, if the depositor deposits funds in bank, not in her own name, but in the name of friend as trustee or in trust for child, this is not a totem trust case, nor is there a totem trust if grandparent has sent funds to parent for parent to deposit in the name of, quote, parent in trust for child, the common way a trust account is started for an infant by a grandparent. In these cases, the deposit was made by someone or with funds from someone other than the one designated as trustee. The account name presumptively means exactly what it says, that there is presently a regular trust, even though obviously in these examples the terms of the trust are unspecified and subject to proof and declaration and clarification by other evidence. The focus of the present discussion, however, is upon deposit of the type in the paragraph above, in which the depositor or source and the nominal trustee are the same person. Number one, question of trust intention, Section 419. Such a deposit is not really clear on its face, and does it does not by itself prove the depositor intended presently to create an inter vivos trust. The depositor may have intended 1. To create a trust upon her death, or 2. Presently to create a trust that is revocable either at the time prior to death. Number 3, presently to create an irrevocable trust, or 4, to create a trust that at all, the form of the deposit being merely to avoid certain restrictions or limitations on insurance protection, or to set up apart funds in case the depositor decides to create a trust in the future. The last of these has no trust intention at all, and although there is trust intention in the first, it is an intention to create a trust in the future and thus of no legal effect. The second and third intention mentioned are permissible forms of trust intention, but the question is whether these intentions have been properly implemented to create a valid trust, and if so, upon what terms. Number 2, validity and effect, Section 420. Faced with these possibilities and uncertainties, courts have developed differing positions with respect to the validity, presumed intention, and effect to be given to these bank deposit situations. A. Presumptively a revocable trust, Section 421. Most cases hold that a deposit by one person of her own money in her own name as trustee for another presumptively creates a revocable trust. The depositor trustee can and does by inter vivos withdrawals, such as simply by writing a check, revoke the trust in whole or in part during the lifetime, whatever is left at his or her death to the named beneficiary in the living. In Ray Toten, 179 New York, 112, 1904. This is the usual intention attributed to the depositor, and the intention is implemented according to the presumed result just described. This presumption is rebuttable, and courts will receive evidence of contrary intention, and will give recognition to other intent if discovered. Restatement 3D, Section 26. Excuse me. Number 1, criticism. The treatment of such a deposit as a revocable trust has been criticized as a legal fiction. There is really no basis for inferring a particular trust intent from the form of the deposit, or for inferring that it was definite enough to be taken seriously. Even if there were, where does the intention to reserve a power of revocation come from? In reality, the depositor may have intended an irrevocable trust, or maybe simply to use the deposit as a substitute for a will. Despite these arguments, the total trust doctrine is widely recognized and is thought to approximate reasonably well what a depositor is likely to have had in mind. B. During depositor's lifetime, Section 422. During the settler's lifetime, a totem trust differs from other revocable trusts in several ways. 1. May be reachable by depositor's creditors. Section 423. In some states, the depositor, settler, trustee is treated for certain purposes as having set up the account essentially as a shield for outright ownership of the deposit. For example, the depositor's creditors in many states can reach the deposit notwithstanding the trust, even in jurisdictions in which this is not true of other revocable trusts. And if the depositor becomes incompetent, his guardian may have use and control of the funds without following procedures that might otherwise be necessary for property placed in a revocable trust. Haziak National Bank and Trust Company versus Taub, 1946. Number 2, terminates if beneficiary predeceases depositor, Section 424. A totem trust terminates automatically if the named beneficiary predeceases the depositor, i.e., the beneficiary's heirs or litigants are not entitled to the deposit, not even what remains in the account at the depositor's death. even though there has been no revocation by the depositor. Hyman versus Tarpley, 1944. C. Depositor's death. Section 425. On the depositor's death, a totem trust is created as a valid inter vivos transfer. So the unrevoked balance in the account is not a part of the depositor's probate estate for most purposes, and the testamentary formalities for its disposition are not required. Restatement 3D, Section 26. Nevertheless, unlike other revocable trusts, which are generally not revocable or appointable by will unless the right to do so is expressly reserved, the depositor's will may revoke the rights of the named beneficiary under the totem trust. Number 1, express revocation by will. If the depositor leaves a will that expressly bequeaths the funds in the account to someone other than the named beneficiary of the bank account, the will is effective to revoke the trust and to leave the funds to the litigant under the will, to the litigee. In re Scanlon Estate, 1933. The mere execution of a will that would bequeath the deposit to another is probably not itself sufficient to revoke the tentative trust if that will is no longer in effect at the depositor's death. In Ray Pozzuto's estate, Pennsylvania, 1936, but see Brooks versus Home Federal Savings and Loan Association, 1951, contra. Number 2, clear intent to revoke required, Section 427. The intention to revoke the tentative trust by will must be clear, and it must be rather apparent that the depositor intended the bank deposit to go to someone other than the beneficiary named in the account. Thus, a mere direction that all my property or all my monies go to another would not be sufficient. One One case even held that the totem trust was not revoked where the depositor's will bequeathed to another, quote, all funds on deposit in any bank, end quote. In Ray Battle's will, 1944, but cases have held that the trust may be revoked in whole or in part by implications such as where provisions of the will would fail and will's content would make no sense, as interpreted at the time of the will's execution without drawing on the funds. Number 3, minority view, no trust, Section 428. Recognizing the criticisms noted earlier, some courts hold the bank deposit trust invalid as an attempted testamentary transfer and recognize no trust at all. Others, without taking the position that such trust would be testamentary if intended, take the position that no trust should be presumed and no trust will be found in the absence of other affirmative evidence of trust intention. Where for either reason there is no trust, the bank balance at the depositor's death is an asset of his probate estate. Powers versus Provident Institution for Savings, 1878, Massachusetts. Number 4, evidence of intent, Section 429. Whatever view is taken of the savings deposit trust situation, evidence is admissible to show the depositor's intent. What evidence is admissible and what is its effect? A, statements and conduct. Evidence of the depositor's statement or conduct at near the time of the deposit and often subsequent conduct are relevant to show her intention or state of mind. B, evidence of intent to create a revocable trust. In many cases that have found the intent to create an irrevocable trust, it has been considered significantly persuasive that the existence of the deposit was communicated to the named beneficiary, and particularly persuasive that the savings account passbook was delivered to the beneficiary. Harrington versus Donlin, Massachusetts, 1942. Exam tip. The more important things to remember about totem trusts, such as a deposit by X and trust for Y, are the depositor retains full control of the money in the account during her lifetime. A totem trust is revocable by 1. The withdrawal of funds, 2. Any lifetime act manifesting the intent to revoke, and 3. Unlike other revocable trusts, contradictory provision in a will. A totem trust does not protect funds in an account from creditors' claims. A totem trust terminates if the beneficiary predeceases the depositor. 3. Revocable trust and substantive policies. Forced share of surviving spouse. Section 432. Can a property owner transfer property into a revocable trust and thereby circumvent policies of the law of decedent's estate, other policies restricting testation or imposing obligations on a decedent's estate? This section addresses the use of a revocable trust to avoid the statutory forced share of the transferor's surviving spouse. Example, under the law of the state involved, testator's wife would be entitled to a 1/3 share of his estate. And if he makes a will giving her less or something different, such as a life estate in his property, she has a right to elect against that will and to take her 1/3 interest outright. During life testator's transfers the bulk of his property to a trust under which he retains a right to the income for life and a power of revocation. At testator's death, he is survived by wife, who elects against his will in order to take her forced share. Are the assets in the trust included in his estate for purposes of determining the amount of wife's forced share, and can she reach them to satisfy her forced share? Number 1, majority view, section 433. Under the prevailing view in the absence of statute, the answer to these questions is no. Soltis versus First of America Bank in Michigan, 1994. This is also the position adopted in the earlier restatement 2D, Section 57, CMTC. This result assumes 1, that the owner was free as is generally the case, to defeat the spouse's forced share by giving away property outright during life, and 2, that the revocable trust was valid, see Supra Section 403 through 406, rather than purely illusory. Number 2, trust that is illusory are mere agency. Section 434. If, however, under the more general rules considered previously in connection with the alleged testamentary character of revocable trust, a particular trust is found to be illusory or to constitute a mere agency because the transferor was deemed not to have parted, even revocably, with any interest in the property, then the property, of course, remains property of the grantor and becomes property of his estate at death. And we have seen, absent peculiar circumstances, this is rarely the case. In most jurisdictions, absent special legislation, the same standard is to be applied in the forced share cases as is applied in the defective illusory trust cases. However, it does appear in some of the cases that the courts have been more responsive to the readily persuaded by evidence, tending to suggest that the trust was entirely illusory when the issue involves the spouse's elective rights. C. Johnson versus LaGrange State Bank, 1978, Illinois. Other views. Number 3. A. Intent test. Section 435. A few jurisdictions have employed an intent or virtual fraud test, asking whether the transferor's subjective purpose in creating the trust was to avoid the spouse's forced share. If such a purpose is found in these states, the spouse is allowed to disregard the trust and have the assets treated as part of the transferor's probate estate. B. Recent statutes and cases, Section 436. Gradually increasing case law and a substantial and growing number of statutes have adopted the position that even though the trust is otherwise valid and in no way defective as a illusory transfer or as mere agency, the rights of the surviving spouse can be asserted against the trust property. See E.G. Sullivan versus Birkin, Massachusetts, 1984. Prospective change of law, Moore versus Jones, North Carolina, 1980, UPC Section 2-202. The details of this right and its measurement vary from state statute to statute. But the essence of these rules is that even though revocable trusts may and generally will pass challenges based on formal grounds, testamentary character, and compliance with the Wills Act, they may not be used to circumvent the serious substantive policy granting a forced share to a surviving spouse. The rationale is that rights under such a trust are so similar to complete ownership that it makes a farce of forced share legislation to allow it so readily to be avoided. Restatement 3D 25, number 2. Number 4, majority view not applicable to dower or community property. Section 437. Even in the majority of jurisdictions, which allowing the surviving spouse's elective share to be circumvented by a revocable trust, other spousal interests cannot be so defeated. For example, where the inchoate right of common law dower or courtesy still exists with respect to land and in jurisdiction that have the community property system, even an outright transfer by one spouse cannot defeat the inchoate or community interest of the other. B. Other situations. Taxation, creditors, and restrictions on charitable bequests. Number 1. Income and estate taxes. Section 438. The Federal Internal Revenue Code and the tax law of most states today make it clear that a property owner who transfers property to a revocable trust achieves no beneficial change in his tax position. For example, the income of the trust will continue to be taxable to the transferor. IRC Section 671 through 677, and the corpus of the trust will be included in his gross estate at death. IRC Sections 2036 through 2038. Not only when the trust is wholly revocable or freely amendable, but also when any of a broad variety of powers or beneficial interests have been retained. Number 2, creditors. Section 439. The law of the various states differ, but the property in a revocable trust often is not reachable by creditors of the deceased settler. And once the debtor settler has died, the federal bankruptcy court is no longer available. Even in those states that do allow creditors of the settler to reach revocable trust assets during life, see Infra Section 946 through 949, these doctrines may not apply after the settler's death, although there are expectations. Compare Restatement 3D, Section 25 to CMTE. Revocable trust assets should be, as needed, subject to claims of settler's creditors or creditors of his estate, and should also be used to determine and satisfy shares of preterminate heirs, adding further that anti-lapse and similar statutes should apply to revocable trust. Charitable bequests, Section 440. The increasingly rare statutes restricting bequests and devices to charity are generally held not to invalidate inter vivos trusts for property purposes, despite the settler's retention of a life interest and power of revocation. Scott on Trust, Section 57.5. Tests to determine whether property in a revocable trust is subject to settlers' surviving spouses' forced share. So the majority view says that transferred property is not subject to forced share because an owner is free to give away property during life. Illusory transfer doctrine says that transferred property is subject to the forced share if the transferor retains so much control over the property to make the transfer illusory. Intent test says that transferred property is subject to the forced share if the transferor's purpose was to defeat the surviving spouse's forced share. And modern case law and statutes says that transferred property is subject to the forced share because revocable trust may not be used to circumvent the policy granting the surviving spouse such rights. So that concludes this chapter, you all. And that concludes the reading for today. I hope you all have enjoyed the information shared today. I will be back tomorrow to finish up to start and finish chapter 4, which we will get into transfer of beneficiaries' interest. This book is highly deep, you guys. And I don't know about you, but I'm definitely going to have to go back and listen to this several times. And I'm also listening to other commentary of being said and the intents of what these trusts are meant to do to seep in so that I can have more of an understanding and overstanding. And you guys probably feel the same because this language that we're um, embarking on, that we're reading, is totally different from what we've grew up reading and knowing about. So this is definitely like an unlearn to relearn type of situation. And it's just deep and um, it's sometimes it can be overwhelming, but um, we have to work together. And you guys can always comment or email me and let me know what you think about the information in the book that I'm reading. I would love to hear your feedback on it. If you have some insight on what is being said here, I would definitely love to hear that as well, because we can all help each other in this investigative type of unlearning or relearn to kind of restructure our lives the way it was supposed to be, moving into the private. So with that being said, I'm going to let you all go for the day. Make sure you guys hit the like button. And if you're new to the channel, please subscribe and welcome. I appreciate you being here. If you'd like to make a donation, just as appreciation or for the continuing development of this information and research, please do so by going to the description area of this video, and you can find the Cash App or my Chime account. If you have Chime, you can simply just transfer to my email or the email that's listed there in the description area. Or you can send it to me directly through Chime. But I truly appreciate everyone's love, generosity, and I'm thankful for your time and thank you for taking the time to listen to this book today. And with that being said, it is your girl, Empress Shay Marie, and I will see you guys on my next video. Thank you and have a great day.